1 CACR 190194, State of Arizona versus Ricci, and appearing via Teams, we have Sharmila Roy and Joshua Smith. I would remind council that we have read the briefs, we've conferenced the case, we are familiar with the facts and the law. We do have questions for council. You're each given 20 minutes to present your side. Ms. Roy, if you want to have any time for rebuttal, it's your obligation to manage that. These proceedings are being recorded, so make sure that you state your name before you present. And with that, we'll start with you, council.
May it please the court. Good morning, Your Honors. My name is Sharmila Roy, and I represent Travis Ricci. And I'd like to save 2 minutes for rebuttal, please. I will keep track of the time. We would like to start to bring this court's attention to the fact that the Biggers-Braithwaite factors on which State versus Deserault is based and the jury instruction, they are now outdated, as shown by many uncontroverted empirical studies that were presented to the court and in all the case law from other jurisdictions that we have presented in our briefs. And the main parts of those new studies, or at least studies that are not very new, they've been going on for a long time, but new to Arizona, is the fact that eyewitness identification has some aspects which are not part of common sense of juries or anyone. For example, when there's the presence of a weapon, high levels of stress, maybe one could figure those out. But things about cross-racial identification being particularly unreliable, or the fact that accuracy of the identification is poorly correlated with the witness's certainty, that is definitely counterintuitive. And also the fact that there's unconscious transference. So if a person buys cigarettes every day from a cigarette seller, and then there's an armed robbery at the store, the cigarette seller might conflate the two and say the customer who bought cigarettes every day is the robber. Now, that is not something that you would expect from common sense. So
Ms. Roy, even if we accept as true your argument that there are many changes to the instruction as required by Deserault, aren't we bound by Deserault? I mean, the Supreme Court told us this is the instruction to give. Aren't we bound to say, yep, that's the instruction you give until they tell us otherwise?
Well, I believe that in Biggers and Braithwaite, the idea was, what should the trial judge consider in order to rule on the reliability of the eyewitness ID? I don't think jury instructions were particularly mentioned in those cases. So
I thought Deserault said this is how jurors were supposed to be instructed.
Yes, State versus Deserault said that, but I thought we were talking about the U.S. Supreme Court.
No, I'm talking about the Arizona Supreme Court, who's my boss, and they tell us, give this instruction, and it was given. So if there's an error with the instruction, isn't that for the Arizona Supreme Court to fix?
Well, I guess in any case, the Arizona Supreme Court will be confronted with this issue. But given that this particular trial court got all the expert testimony and all the articles that summarize the scientific testimony, I think in that case, the trial judge was not bound by the Raji. He could have given another instruction. Trial judges can give, change the Raji. He changed it for the accomplice testimony, and and added some words. So he could have said, well, there are certain other things that have come into focus because of studies, and so there's no reason to keep to something that was decided many years ago, and there has not really been any other case law from the Arizona Supreme Court. So we believe that the trial court was within its discretion to change it and add some things to it. For example, one could say that, well, the witnesses' certainty is a factor, except that one should take into account how whether the certainty was well founded, which is what the Hawaii jury instructions say. And that certainly would not be against Deserault. It wouldn't be violating it. So uh, we believe that the jury instructions in this case could have been given. Now, as far as the suggestive pretrial identification, once again, even though it was happenstance that the two people, Wellmaker and Ricci, were playing chess together and the tattoo got shown, I think when the police decides to or puts two together, maybe it's not intentional, but it's because of them, that you should believe that within 5, 6, whatever number of days, there is a possibility that people will know about who the other people are. In fact, Wellmaker said that friends at the jail knew that this incident had happened. So it was very probable that they would have met, and that the indelible features, the features would become indelible in Wellmaker's mind. And as far as the actual identification,
excuse me, but again, as we're talking about state action, is that the only case you found, the case cited in your reply brief? I think it was the Third Circuit, because factually they're very different cases. In that case, there was in the transport to the courtroom versus here, where it's just in the jail. Hundreds and hundreds of inmates in that jail, and they happen to be put in the same pod.
Well, but the point is that he didn't walk in there of himself. The police or whoever puts people in the jail put them there. And similarly, when you transport people, you can say that, oh, so many people have to go to the court today, we just put them in the bus. So it's not, of course, the facts are always different in cases. They are not exactly on all fours. But there was, and in fact, if the trial court had been absolutely certain that there was no pretrial suggestivity, it wouldn't have even gone into the bigger factors. The fact that the trial judge didn't consider other factors which are in the, as I said, empirical studies have proved, that's one thing.
Hold on, because it is important, because you recognized it even in your brief that there has to be state action. And I guess that's my problem, is I don't see state action just because there are two inmates within the jail that happen to run into each other.
If they're placed in the same pod and they play, people play cards together, they take off their shirts, it's not an unusual occurrence. So if they didn't take care that these things don't happen, then that is either their procedures or something is at fault here. But as I said, the trial judge did say that even if it was suggestive, it's still not, something that it can be considered unreliable. But before that, there was, Wellmaker could not identify it in a lineup. He said he had only seen, the build and the tattoo. And once again, there are two identifications here. One is the identification of the guy who called him racial slurs. There's another identification of the person who was in the car. And the two are being conflated here, and they were conflated by the trial judge. Even arguably, if one could say that the identification of the accoster was correct, it still wouldn't be, the identification of the shooter was unreliable, because this person is in a car. You cannot see the tattoo or the build. The Wellmaker said he had a hood on his head, so you can't see the bald head. He's in a car with the headlights are on. The headlights are on, you'll see something ahead of it, not behind it. Similarly with the gun pointed. out. If there's a flash, you'll see things ahead of the flash, not what's behind the flash. So the idea, yes, Wellmaker may have thought, well, I'm sure there's the person, because who else would have come? But that's not what identification is about. But even if the judge didn't consider the anything more than the bigger factors, the jury should have been instructed according to uh, and taking into account and incorporating the new studies. And there was the argument in the Desert hearing. There was some statement that accuracy is not, is poorly correlated with certainty. But the number of studies and oral argument happened at the jury instruction stage. And so at a very minimum, the jury instruction should have been tailored to take into account the cross-racial identification and, of course, the presence of a weapon, the stress level, and as well as the fact that certainty is a poor indicator of accuracy, because without that, the jury had no.
But Ms. Roy, all of this information was presented through your expert witness and argued extensively by both sides. I guess I'm failing to see the prejudice to your client, especially given the fact that the victim identified the tattoo, it was reconfirmed he had the tattoo, and there were other witnesses who, the co-defendants, I'll call them, that testified or pursuant to testimonial agreements. I don't see any prejudice here.
Well, if you think of the other people who are, who are all gang members, and they are, they are fully fledged members. Ricci is a probate, that they can decide to throw him under the bus. Detective Dalton tells Michelle Schmidt all about the details, and they have lots of time to get their stories together. So if you think of them as not, if you take that with caution, then in fact the only person putting Ricci there in the car at that position is the testimony of Wellmaker. So we don't we don't.
So, Ms. Roy, what you just said is, if we ignore all of the other evidence, then the only evidence there is him putting him in the car.
No, I don't think I quite said that. I said if you take it with the great caution that should be given to accomplice testimony and testimony of people who are accomplices and their family and their friends who are all together and who really have a lot of background that they want to hide, or they want to escape from the results of that. And if you take that into consideration, then the Wellmaker's ID becomes very, very important. And there, if the jury had been given the right instruction, nobody knows what would have happened. But I think that without that instruction, prejudice was caused to my client. Now, if you have any other questions on the identification, if you don't have any, then I will go on to the cross-examination about the rape allegations against Wellmaker. The judge, of course, decided that he couldn't be cross-examined on that. Now, we all know that any motive or bias of a witness must be presented. The defendant, to get a fair trial, he must be allowed to explore the motive or bias. But he also must be allowed to explore the credibility of a person. And if the cross-examination could have happened, the fact that he made such an absurd story about how his semen got into the complainant, I mean, he obviously thought it would be found, and that that some ex-girlfriend stored it and gave it to the new girlfriend so that they could make him look bad. That is so absurd that I think any presentation of that to the jury would have been, very crucial in their decision whether to believe Wellmaker or his identification at that dark place in the car for a few seconds of a man in a hood. So I think that that particular, cross-examination, the fact that it wasn't allowed created error that denied my client a fundamentally fair trial. The final thing that I would like to talk about is this so-called great caution instruction. Federal.
Let's talk about the flight instruction.
Okay.
Do you have any cases, or what's your best case that would say that you can use a flight instruction based on accomplice liability versus the actual consciousness of guilt for the defendant on trial? Do you have any? Were there any cases like that?
I thought I had mentioned one in the opening brief, but unfortunately I don't have it right in front of me. But in the flight instruction, I had said that there was a case that said that the hiding by the accomplice is not necessarily, is not something that can be attributed to the defendant, and it is the defendant who's on trial. So if the accomplice hit the car, and there was no testimony that he did. And so, yes, definitely a new trial should be ordered without the flight instruction. But as far as the great caution instructions, I think that, as I was beginning to say, the federal courts have, since Jimmy Hoffa's time, have given the great caution instructions to accomplice and snitch testimony, because it's well known. And even in Kansas versus Ventris, I think the U.S. Supreme Court said, well, if an instruction is given, we are not going to bar such testimony, even though it's inherently unreliable. We know that. But an instruction should be given. And many state courts have given such instructions. And I have noted in my reply brief different state courts that have said these are not comments on the evidence, and that cross-examination and closing argument are not sufficient, because juries basically look at, consider the judge's instructions more carefully than closing arguments or even expert testimony, because that's, they can decide whether to consider those, but they cannot decide whether to consider the instructions, because the instructions they are presumed to follow. So this instruction simply that those people might have some motive to fabricate is not sufficient. I think juries should be told that there is some inherent, courts know that there's some inherent unreliability in accomplice testimony, and that there should be some caution to the jury. And that doesn't mean a comment on the evidence. It just means that you just say that this in general should be looked at with some caution. And whether the jury decides to, what the jury decides to do with the caution is not something that anyone can go into anyway. I think I'm too, if I understand it, I've had 18 minutes. So I will, if you have no other questions, I will stop here and keep 2 minutes for rebuttal.
Judge Bailey, Judge Winthrop, any questions?
No, thank you.
All right, Mr. Smith.
Thank you, Your Honor. Can you hear me? I'll also be keeping my own time. May it please the court, my name is Joshua Smith, Assistant Attorney General representing the state of Arizona. This court should affirm Ricci's convictions and sentences following the trial. Going with the issue regarding the eyewitness identification instruction, the issue with that is really whether the instruction as given deprived Ricci of a fair trial, not whether the instruction needs to be changed at all. As Judge McBurney noted, that's really something for the Arizona Supreme Court to do, or possibly the Ricci Committee to do. But the instruction as given satisfied due process. The instruction tells the jury they may consider a number of factors, including any other factor that might be relevant to the reliability, and which would necessarily include all the factors that Ricci wanted in his proposed instruction. It would necessarily include the information that his expert testified to. And then you combine that with Ricci's closing arguments, which focused heavily on the reliability of Wellmaker's identification and tied it into his expert's testimony. The instructions as given were sufficient to inform the jury and did not deprive Ricci of a fair trial. So the instruction that the court gave satisfied due process. I will note that in Perry v. New Hampshire, the U.S. Supreme Court in a footnote cited favorably to the instruction that Ricci gave as an example instruction that would caution juries against placing undue weight on eyewitness testimony of questionable reliability. They also noted the right to confront and be assisted in giving closing arguments as other safeguards that would caution juries against placing potentially unreliable instructions. So, given the totality of the circumstances with the instruction as given and combined with Ricci's arguments, Ricci received a fair trial with the instruction he gave. The court wasn't required to give his proposed and modified instruction. And going back to Judge going back to Judge McGree's question regarding the flight instruction that he asked Ms. Roy.
Well, before you move on to that, I'd like you to address, just because it was put in the reply brief, what about the idea of state action? How do you respond to the federal court's determination that placing inmates in a same transport is state action?
Well, I would note that U.S. Supreme Court and the Arizona Supreme Court, both, when they talk about state action, they're talking about state action in relation to identification procedures. And simply housing Ricci in the same jail pod as Wellmaker is unrelated at all to any identification procedure. I would also note that the Shavers case that's cited in the reply brief is distinguishable. And Shavers, as the witness, is being transported with defendants to a court and held in a holding cell. I believe in Shavers, there were 3 defendants total. The witness identified 2 of the 3, but all 3 were held in the same cell with the witness, and it was transported and connected with a scheduled court hearing. So Shavers is more akin to Arizona cases, finding in-court identifications unduly prejudicial versus housing them together in the same pod at the jail. There's no evidence that the police ever recontacted Wellmaker about doing another identification after he was released from the jail cell. Outside of Ricci approaching Wellmaker and identifying him, there's no at all from the record that would show that this would have influenced his identification at all. So while the state is involved in the sense that they house them together, this isn't the kind of state action that the due process clause is concerned with, because it's unrelated to any identification process. And because there's no unduly suggestive identification procedures, the court wasn't required to preclude the in-court identification, and that's really the end of the analysis. I know the court did engage in the analysis, but I think that's more just the trial court being thorough, given that this was a capital case rather than the trial court finding anything suspect. The trial court specifically found there was no suggested pretrial procedures used.
Well, in that same vein, how did the state become aware that this identification had taken place in the jail?
I don't recall specifically from the record how the state became aware. It may have been in connection with some sort of interview with Mr. Wellmaker. I don't recall specifically from the record how it is the state first became aware of it. I know that they, and as part of the record, there was the video footage, video footage from the jail pod of Mr. Wellmaker and Ricci playing chess together. But there's no evidence that the state conducted another photo show up or photo lineup with Mr. Wellmaker after he was in the jail, outside of showing him the photo lineup in connection with his testimony. There's no evidence that they did another lineup or did any contact him again about trying to recontact Ricci after he was in the jail. So the in-court, the identification of Ricci is really unconnected. Or excuse me, the state wasn't the housing decision is completely unrelated to any sort of identification procedure, and because it's not connected to an identification procedure, that's not the kind of state action that the Supreme Court and the Arizona Supreme Court have discussed in connection with the death row issues. Judge McMurray did ask about the flight instruction, if there was any case law about whether a accomplice's actions could warrant the instruction. My recollection from the record is the witnesses testified that everyone at the Malta house were involved in trying to hide the vehicle. And based off that testimony, I'd say that's the highest evidence that would support the instruction. But even if I'm misrecalling the record, the instruction as given is telling the jury that if they find there's evidence of flight or concealment, they may consider that as evidence of guilt. And if it turns out there is no evidence that Ricci was directly involved in flight or concealment, the jury, in following their instructions, would have ignored the rest of it, because if there's no evidence of flight or concealment, then there would be nothing for them to consider. So even if there wasn't the slightest evidence to support the instruction is harmless, just because juries follow their instructions, or presume they do. And if there was no evidence to support the finding that Ricci was involved in flight or concealment, then the jury wouldn't have had to consider that for evidence of guilt or any.
That would be true in every case, and this court has reversed cases for giving an improper flight instruction.
Well, the state stands by its briefing that the evidence at trial would support it. The standard for giving the instruction is the slightest evidence. And again, my recollection of the record is witnesses testified that everyone was involved in trying to hide this vehicle. I believe there was some testimony that Ricci may have been involved in trying to find the shotgun shells in the back of the car, which would help support that he's trying to conceal evidence, if not fleeing the scene. So there is some evidence that would support the instruction. The standard for giving the instruction is the slightest evidence. So the state's position is the evidence that support giving the instruction. And under the totality of the circumstances here, reversal for that one instruction would be unwarranted, even if the court thinks
Mr. Smith, isn't it an overreach to give the instruction in this case?
I don't believe so. I think there's evidence that supports the instruction, and the standard for giving the instruction, again, is the slightest evidence. There was the slightest evidence here.
I didn't see any cases in your brief where you, given the instruction, supports. The instruction is supported if it goes to an accomplice. In the evidence, because if that's acceptable, yeah, there was plenty of evidence to show that the accomplices were concealing evidence. But there's not much evidence in this record that would support that Mr. Ricci was concealing evidence, is there?
Again, Judge, my recollection of the record is the testimony was everyone was involved. I believe that there was some testimony that Ricci was involved in trying to locate the shotgun shells that Malpa subsequently buried. So Ricci was involved in trying to locate the shotgun shells. That, the only reason to do that would be to conceal that evidence. And if everyone is involved in trying to hide the vehicle, that would necessarily include Ricci, so that there's evidence of Ricci's involvement, or at the very least, there's slight evidence of it. There's evidence of involvement. The standard is the slightest evidence is sufficient to support the instruction, and under that standard, the instruction is appropriate. The trial court did not use its discretion in giving the instruction. The trial court also acted within its discretion when it denied Ricci's request to cross-examine Mr. Wellmaker about the uncharged sexual assault allegation. The evidence of the sexual assault allegation itself is irrelevant to Mr. Wellmaker's credibility. He's not less credible because of the allegation. And it's only when you get into the weeds of what he told to the police that you can get to possibly suggesting a reflex on his credibility. But Rule 403 exists to keep out this kind of evidence. It would essentially turn the case into a miniature trial on the sexual assault allegation before the jury could determine Mr. Wellmaker's credibility. Given that risk, the trial court acted within its discretion under Rule 403 to preclude it. Because the court acted within its discretion, there can't be a Sixth Amendment violation, because the Sixth Amendment recognizes that trial courts have broad discretion to limit cross-examination to avoid confusing the issues or going into marginally relevant evidence. And so under the circumstances here, the evidence of the uncharged sexual assault allegation had marginal relevance related to his credibility at most. And given that it created a substantial risk that the jury would be bogged down on this, issues completely unrelated to the charged conduct before they can make a credibility determination, the court acted within its discretion, particularly when you consider the plethora of other impeachment evidence they got into. And so far as the allegation could suggest, the trial court or Mr. Wellmaker had a motive shape his testimony, the state could have rebutted that using his testimony from the death row hearing, which predated the allegation by 2 years. The testimony at trial and the death row hearing is largely consistent. The biggest difference is at the trial, Mr. Wellmaker admitted to criminal activity he did not admit to at the death row hearing. And I think, I forget which hearing he said there was a hood and which hearing he didn't, but that's a minor distinction. But the core of his testimony identifying the man who accosted him, the man who fired the shotgun, remains unchanged. And when he testified at the death row hearing, he didn't have the motive to his testimony due to a suggestion that he wanted leniency on this uncharged sexual assault allegation. So the state could have rebutted it. So even if you think the court should have allowed it in, it's harmless given all the other evidence that came in, along with the state's ability to rebut it using evidence that predates the allegation. Finally, regarding the due care instruction, again, this issue was the denial of this, or the instructions the trial court give, did that deny Ricci due process of law? And the instruction as given, combined with counsel's argument, did not deprive Ricci of due process. The court modified the standard witness credibility instruction to tell the jury they can consider whether the witness received any benefits, monetary or otherwise, in determining the witness's credibility. Ricci's closing argument was heavily focused on attacking the credibility of the various cooperating witnesses. And I think, in general, juries, I think, especially with these witnesses, would be skeptical a little bit of these witnesses. A lot of them are implicated in other criminal activity. Some are implicated in multiple other murders. So I think your average juror is going to, think that these people would have a reason to try to downplay their involvement in some of this activity. And while the federal courts might give the instruction, that's not the same thing as saying due process requires this instruction. Regarding Ricci's argument that it's not a comment on the evidence, I know he cited to a Washington case, State v. Carruthers, but my reading of Carruthers, it's to acknowledge that the due care instruction would normally be considered a comment on the evidence, but they've adopted an exception for accomplice testimony because Washington has a policy disfavoring accomplice testimony. Arizona doesn't have that policy. As Ricci notes in his reply brief, Arizona used to have a statute prohibiting the offering of uncorroborated accomplice testimony at trial, but that statute was repealed 45 years ago. It hasn't been readopted. The courts haven't adopted a similar rule. So Arizona doesn't have a similar policy against using accomplice or eyewitness or informant testimony. And again, the instruction as given, combined with the arguments, was enough to let the jury know that these witnesses, there's issues with these witnesses' credibility when they're weighing their credibility. And under the totality of the circumstances, the instruction as given, combined with the arguments, did not deprive them of a fair trial. Unless this court has any other questions regarding any of the other issues in the briefing, the state would ask that it affirm Ricci's convictions and sentences and deny the relief requested in his brief. Thank you.
All right, Ms. Roy, any final word? I believe you're on mute, Ms. Roy. Ms. Roy, you're on mute.
It says unmuted now.
Yeah, now you are.
Okay. Sorry. As far as Rule 608B, it says extrinsic evidence is not admissible to prove the instances of, the conduct to attack his character for truthfulness, but the court can allow it. And because extrinsic evidence is not admissible, but cross-examination is, so it's not clear that cross-examination would have resulted in a mini trial for rape. That is not something that would necessarily have happened. Now, as far as the identification is concerned, it's the first time he identified, Wellmaker identified anyone, the photograph, was at the Desert hearing. So basically, and that happened after the prison encounter. So the encounter with someone who isn't isn't accused and whose obviously probable cause has been found, that's why he's in jail, and had been in jail since, according to Wellmaker, I mean, obviously for 2 years. So therefore the eyewitness identification at the Desert hearing itself was prejudicial, because they were, that happened after the prison. And as far as the flight instruction, there is really no evidence that Ricci was involved. In fact, there's no evidence that Ricci tried to get the shotgun shells. It was Ryan Moldva who tried to get it, who found it, and then buried it. So as far as the flight instruction is concerned, it doesn't really, there's no evidence that suggests that this was something that Ricci did. And if you have no other questions, then I think my 2 minutes are over.
All right. Judge Winthrop, Judge Bailey?
No, thank you.
All right. The matter is deemed submitted. We'll issue a decision in due course. Thank you very much for your participation in the argument and the briefing in this matter. Court stands at recess.
Thank you, Your Honor.
Thank you, Your Honor.